Do you have that question?
I think that is enough. Your Honor, Honorable Mother Koome, we want to welcome you to this interview on behalf of commissioners, and thank you for being here. And just to let you know that we hope it will be more of a conversation so that between you and us, and please relax, Judge, and answer your questions as precisely as possible. The interview will be by all of us, the 9 commissioners. And now I'd like to the commissioners to introduce themselves. And I'll start. My name is Professor Olive Mugenda, Commissioner, representing the public, and also chairing these interviews. And to my right.
Good morning, my lady. I am Philomena Mbetemwilo, the elected representative of the Supreme Court to the Commission, and the Deputy Chief Justice of the Republic.
Good morning, Judge. I'm Patrick Ishohi, representing the Public Service.
Good morning, Your Ladyship. David Majanja, Judge of the High Court, representing Kenya Magistrates and Judges Association as the male representative.
Good morning, Judge. My name is Oluwande Evelyn, Chief Magistrate. I represent the female representative, of KMJ. Thank you.
Morning, my lady. My name is Machari Njero. I represent the Law Society of Kenya.
Good morning, Judge. My name is Felix Huske. I represent the public.
Morning, my lady. My name is Mohammed Warsame. Welcome.
Very good morning, my lady. Kihara Kariuki. I am the Attorney General, and I'm a member of this commission by virtue of that office.
Thank you, commissioners. Honorable Judge, if you're not sure of any question, you can seek clarification from commissioners or ask the commissioner to repeat the question, just so that you are clear when you're answering that question. So I'll kick off the interview, Your Honor, by asking you to tell us very, very generally, because I'm sure your fellow lawyers and judges will ask you more, but tell us generally what you perceive to be the role of the Chief Justice.
Thank you very much, Madam Chair. Thank you very much, Honorable Commissioners. Thank you for inviting me to this interview to defend my application for the office of the Chief Justice. The role of the Chief Justice is spelled out in the Constitution and in the Judicial Service Act and other statutes. The Chief Justice is the end of the judiciary. He is the President of the Supreme Court. He is the Chair of the Judicial Service Commission. He is the Chair of the Kenya Law Report Council. He is the Chair of the National Council on the Administration of Justice. In his role as the end of the judiciary, he delegates duties and responsibilities to the Honorable Deputy Chief Justice. He also liaises with the President of the Court of Appeal, Principal Judge, and Principal Judges of other courts of equal status, including overseeing the Chief Registrar of the Judiciary, who is the accounting officer. He also chairs the JOLAC, that is the Internal Leadership Committee, comprising of all the leaders of the various courts. He is the link between the judiciary and the other arms of government. he swears into office the advocates. He also swears into office the president, the deputy president, and also the constitution commissioners. We have like 15 of them under chapter 15 of the constitution. He is the one who swears them in the office. I think when I'm Chief Justice, we will consolidate all those roles, write them in a booklet, and post them so that at a glance you can be able to see the role of the CJ, because there is more, like he advises also the president when to dissolve parliament if they have not enacted the law. So there are more other things, but basically that is the role of the CJ.
Thank you very much, Honorable Judge. Please tell the Commission and the Kenyans who you are, Judge, in terms of you as a person, in terms of yourself as a judge, and also in terms of yourself as a leader. Those three parameters, please explain to the Commission whom you are.
Yes, thank you very much. My name is Martha Koome. I'm a judge in the Court of Appeal. I'm ending the criminal division at the moment. I have 3 years of experience, and a significant portion of those years have been served in public. I was admitted in the bar, having completed my degree in law in 1986, proceeded to the Kenya School of Law and graduated and was admitted in the bar. I subsequently did a master's degree in 2010. I have also done other professional courses to enhance my skill. I have practiced law for 15 years and before I became a judge. And my practice of law was in wide range of areas of law. I did not just practice law also to earn money. I was actively involved in public interest matters that solidified into constitutional review and law reform. I was a council member in the Law Society. The former Chief Justice, Dr. Willy Mutunga, was my chairperson, and we participated in the clamor for the review of the Constitution of Kenya 2010, participating all the way from Kamukonji, Ufungamano, and I was a delegate at the Bomas of Kenya. I'm proud to be associated with the 2010 Constitution. I was chairperson of FINDA, and in FINDA we spearheaded law reform that has led to a raft of reforms that now protect family. I was invited while at FINDA to join the expanded legal sector reform committee that was led by the judiciary. Justice Omoro was our chairperson. We had all the stakeholders in the administration of justice, and we developed the blueprint that informed the reforms in the justice sector that was later on known as the GJ laws. In fact, while at the GJ laws, and in the family division, where I worked for 3 years, and I made reforms there, introduced a checklist and a bench book that helped the courts finalize the cases expeditiously. I was transferred to Nakuru, where I was the resident judge, and also initiated reforms there, case management strategy, court user committee. I also served at the Milimani Commercial Court. I served at the ELC, and I was appointed. I was later on transferred sometimes in 2009 to Kitale. Kitare was a troubled station then because there was a standoff between the advocates who were protesting against a judge, and there were no proceedings going on for a whole year. So when I went there, I was able, using my management skills, to quell the advocates, and we had a good working relationship. I was able to organize the work and worked in the mobile courts at Kakuma and Rokicha. I'm proud that the court we started as a mobile court in Kakuma now is a fully fledged court, a magistrate's court. So I was then transferred or promoted to the Court of Appeal. I've worked in Nyeri. Our bench in Nyeri is credited to have cleared the entire backlog and brought the station to real time. And that was a feat that has never been achieved anywhere in the Commonwealth. I worked in Mombasa, Marindi. Currently, I'm in the Court of Appeal here in Nairobi, ending the criminal division, where I've also initiated changes, was instrumental to the development of the practice directions, civil appeals that enabled the courts to manage the cases and reduce the backlog expeditiously, because it introduced a call over for the cases, so only the cases that are ready, that are fixed for hearing, and they proceed and we complete. Just now completed another practice directions on the criminal appeals, and also the Court of Appeal registry manual that I've worked with the stakeholders and the Court of Appeal staff. In a nutshell, that is what I am. But my background is that I'm born in rural Kenya, in Meru County, a village called Kevio. I think I need to bring that background. It is important because I grew up from an humble family. We were 18 children from 2 mothers. My father was a polygamist. I was number 8 from my mother. So my leadership as orientation started early as the 8th child of my mother struggling to, as a peasant, to put food on the table. I started mimicking her to see how I can help her reduce the burden on her. So I started working hard with my mother. I learned handwork from her. And because of her commitment, I was able to go to school. And thank God I was able to complete and to reach where I am because of the very good training that has grounded me well.
Okay. Thank you very much, Honorable Judge. Just a follow-up question. Please tell us whether you are a visionary leader, a transformative leader. I know you may have mentioned some of that, but just focus on, are you visionary, are you transformative?
Thank you, Chair. I believe I am both. I start by seeing the big picture of what it is that I want to do, the objective of the judiciary, and what we need to achieve. Is it clearing the backlog of cases? Is it ensuring that we have adequate resources to enable us do what it is that we have to do? So my leadership is situational, is consultative, is participatory, and throughout my life, the small nuggets I've given have been in leadership positions. From the Law Society Council member, I forgot to say I was also a member of the Council of the East Africa Law Society. In fact, it is my council that founded the East Africa Law Society when the community was also founded. So I was the inaugural treasurer and participated also in the community treaty document and in establishing the community bodies such as the East Africa Court of Justice. I've also served in the African Union as a commissioner between 2005 and 2010 when I was appointed by the heads of state, sitting at SILT to represent Kenya as the commissioner at the African Committee on the Rights and Welfare of Children. So what I bring is regional expertise, leadership also in regional bodies, in local bodies. I was the chair of FINDA. I also have international experience, having worked with international bodies like the UNICEF, the UN. I am a certified human rights trainer by the International Institute for Justice, that is headquartered in Malta. I'm also a recognized human rights trainer by the Commonwealth Secretariat, having authored for them the bench book manual on gender-based violence that is used to train judges and magistrates in East Africa. So in this office of the judiciary, I am a transformative reader because having participated in the transformation initiative by the Kenyans themselves to reform the constitution, to reform the law, to reform the justice institutions, and the work that I've done in the courts, in the family division as resident judge in Nakuru, resident judge in Kitare, starting the mobile courts, being the chairperson of the Kenya Magistrates and Judges Association, puts me in good stead because I have good strategic partnerships from inside, from the magistrates whom I have interacted with as their president, and also with the stakeholders. I've just completed a very good exercise, very delicate and very important, on preparing a report on the state of children in the administration of justice. That is the NCAJ, the National Council on the Administration of Justice, Special Task Force on Children Matters, where we went around this country looking at the situation of children and making recommendations on what needed to be done, from the law reform, reviewing the Children Act, reviewing the practices, reviewing the procedures, and putting together all the policy documents that are needed to protect children. And for that, I was acknowledged by the UN, becoming the runner-up person of the year 2020. So I bring local, regional, international experience to the leadership of the Office of the Chief Justice. Thank you.
Thank you very much, Honorable Judge. Last question from me. What challenges have you faced as a lady leader, as a judge, in your career? And the second part of that question, Honorable Judge, is if you become the first woman Chief Justice in Kenya, what challenges do you expect to face, and how are you going to go about mitigating those challenges? Thank you.
Yes, I think that I believe the challenges that we face in the judiciary are completely gender neutral. They are the same challenges a male judge or a male judicial officer will face. But it will be historical for this commission to nominate a woman for the office of the Chief Justice, because it has never happened before. Leadership also is generally it's gender neutral. It doesn't require a man or a woman. None of the attributes of my being a woman or being a man would do anything in the office of the Chief Justice. It is the leadership skills. It is skills that will deal with the challenges that we face in the judiciary. Leadership, to me, simply put, is like driving a car. Whoever sits on the driver's seat, so long as you have the proficiency of driving, you have a driver's license, you know how to drive the car will go. That is the same as leadership. Whoever sits on the leadership seat, all you need are skills in the office of the Chief Justice. You need people skills, interpersonal skills to deal with the people. You will deal with the judges, very senior jurists in the Supreme Court. You deal with the judges from the Court of Appeal, High Court, learned people in their own right. You deal with the bar. You will deal with the stakeholders. You deal with the executive. You deal with the registration and everybody. So you need skills. You need also managerial skills, because you will be oversighting, various things. No micromanaging, because you have the CRJ, you have the departments, but you must understand, what is required of you. So as a lady, I appreciate everybody brings to the table something. So in the leadership, you are supposed to have, both men and women. So I'm very amiable to work with, so I can work with a cross-cutting range of people from diverse backgrounds, from diverse professions.
But you must have come across some challenges, maybe not necessarily as a lady judge, but generally in your career. I'm still interested to hear some of the challenges that you have faced,
yes,
how you have gone about them, and also what challenges you expect to face,
yes,
if you become the Chief Justice.
Yes, the particular challenges I faced them as a judge. I just discussed the challenges I faced when I went to Kitale. It was a court that was not operating for a whole year. So when they had a judge has come, so I had like 1,000 people appear in court one day. So what I did was to look at the portfolio of the cases that were there. I saw the prison was beaming, so I did revision of the sentences, and I was able to reduce the population of the prison by reducing the sentences. If you have been sentenced to serve 3 years and you have already served a year and there is a report that you are a person of good conduct, I would commute that sentence to the period served depending on the report, or commit you to community service so that you leave the prison, you serve from home. Then I looked at the other portfolios. Succession matters were so many because no grants were being used, and families who come to for succession matters, for the letters of administration are really hurting. They have lost a loved one, they are stranded. They need the grant so that they can move their lives forward. So what I did was to just sit there for 2 weeks and just completed like 1,000 grants that were clogging the system. And then employing the pre-bargaining in murder cases, because there were very many murder cases that were pending. Pre-bargaining is a system that is around in the law. When I read the files, I saw the ones which were really not murder per se, but were like manslaughters, but people have been charged with murder. So I was able to reduce the backlog of cases, and by the time I left after 1 year, the station was completely normal, up to date, working. In Nakuru, I also faced challenges because when you are the resident judge, you're in charge of a very large region. Those days, there was no high court in Naivasha. There was no high court in Nyahururu, Bomet, Kericho, Narok. All that area we covered it as Nakuru. And we were only 3 judges. At one time, my other 2 colleagues were involved in tribunal hearings. So I would be alone in the station, all alone. And in the midst of all that, as we were trying to organize the work, some key magistrates were transferred from the station. So that now the lawyers came to ask, now what are we going to do? That court is not operating, the other court is not operating. So I would write letters to the Chief Justice asking that we get replacement magistrates, but as you know, because you have looked at the reports of the judiciary, we have always had a shortage of judicial officers. When the next time the advocates came, I told them, look, I don't hire magistrates. If I did hire, I would have hired actually 5, not even 1. So you go to Nairobi and seek an appointment from the office of the registrar to see the CJ. And that's what they did. They came, they saw the CJ. And that same week, by the end of the week, I had letters posting to magistrates in Nakuru. So there are many challenges on the backlog of cases. Is the major one because it affects Kenyans, and Kenyans want their cases to be heard expeditiously. Thank you.
Honorable Judge, we all have people that have helped us shape who you are as a professional, as a person. Who is your role model? Who is this person, or who are these people who have shaped you to be where you are today?
Thank you. I think I mentioned my mother, who had nothing, just tilling the land, but continuously playing for us, the girls, because we were 18, and we were, from my mother, we were 9, 5 girls, 4 boys. I was very close to my mother, so I learned handwork from her, prayerful. She was so prayerful. She would pray for us, kneel down until her knees really showed the marks for prayers. And she would wish that we went to school and that we were empowered so that we were not like her. So she is first and foremost my role model. Then my sister, who had beaten the odds in 1973, also graduated as a teacher. Graduation was celebrated in the village as the first one. And I told myself as a little girl then, I am going to graduate. How? I didn't know. But I kept my eyes focused on graduating. Later on, I've come to know other people like Professor Rea Marango, whom I've looked up because I also got married early. I was a young mother trying to balance a career. Trying to balance my family, and I looked up at Professor Rea Marango, how she was also able to balance family life, career, and becoming the top, the first professor in East Africa. And also my friend, Dr. Jennifer Area. Those are women I looked up to, they were closer to me. But later on, I've seen other women judges from all over who have inspired me in a big way.
Thank you very much, Honorable Judge. And I will now request Commissioner DCJ to ask you questions.
Thank you, my lady. You have been an insider for how long?
18 years, my lady, acting Chief Justice.
18 years, and most of the time you've been judge, you've been presiding judge. Resident is where we began.
Yeah.
Please tell us what you perceive to be, or what you do know to be, the administrative and judicial challenges in the judiciary right now that my lady will make a priority to fix.
Yes. Thank you very much, my lady, acting Chief Justice, for that question. The administrative challenges are many. I'll begin with the human resource register asset. When I was preparing for this interview and looking at the reports, especially the last State of the Judiciary report, it indicates that the human capital is at 46%. 56%. So we have a deficit of 44% of the kind of workforce that is required in terms of judicial, administrative officers, magistrates, and judges. We all know the shortages of judges that we have. We also have budgetary constraints because also looking at the reports, it shows that the judiciary receives 0.86. It doesn't receive a whole 1% of the national GDP. It's underfunded. The judiciary fund that is supposed to attract proper management and independence of the institution, secure the independence of the institution financially, has not been operationalized. So that is also a big administrative challenge. The other challenges are coordination of the core business of the judiciary, that is the work that judges do, to link it up with the support that we get from the staff, and to be able to consolidate everything and move seamlessly. Part of it, like in the Court of Appeal where I sit, is because of the infrastructure problems. It's also a challenge. IT, technology. Thanks be to COVID, that we have been able to embrace some rudimentary technology to do our work. We have to struggle with that until we make it work. But that is also a challenge. I'm just talking of the challenges in the Court of Appeal because, like the chambers of the judges, the secretary sits like 100 meters away from the judge. The researcher also sits maybe 200 meters away, you know. So the coordination of work so that we work smoothly is a challenge. Judicial, also one which cuts across is the shortage of judges, magistrates, and the shortage of infrastructure in some stations. There are some stations that do not have, you know, judges. As we sit here, the Court of Appeal is not sitting in Nyeri or Mombasa. So those are challenges. And also, judiciously, the way we deal with the public and interface with the public, I think there is also a challenge communicating effectively, especially the judicial side with the public, for them to know how we designed our cases, what is judicial independence, so you know, what is judicial interdependence. So we have a few things to iron out there. Thank you.
Please, my lady, give us your solutions.
Solutions. Beginning with the admin, I think the solution is to get the judiciary fund operationalized. I know the act or the bill to operationalize it is either in Parliament, in the floor of Parliament. So the solution here is to fast track it, and once it's operationalized, we can attract funding. The judiciary has always been supported by donors. We can get the government funding. The 17 billion that I heard was given to the judiciary. If it is put in the judiciary fund, and then we get other support from partners, it is put in the fund. Judiciary also collects revenue. I don't know whether it can also be put in the fund, but my view is that if it is put, then judiciary will never lack money to complete projects, because there are so many projects that are also stored, because even if we get the 17 billion, it is dispersed in tranches and in periodically. So sometimes it's delayed, and once you delay contractors, then you end up paying more. You end up losing value for money. So institutionalize or operationalize the judiciary fund, and then put in audits so that you get value for money. Because once you are able to account for what you receive and account perfectly and show the deliverables, you'll always attract money. Deliverables will always attract money. So have a system that monitors value for money. And then for the judicial challenges, we just have to get judges in the office. There are 41 judges who are pending appointment by the executive. We have to negotiate for them to take their positions. Like the Court of Appeal is running on almost less than half the regiment. So it's absolutely necessary that judges get appointed. When it comes to communication with the public, because really the public want to know why their cases are delayed, we must have a very good communication system. And I looked at the SJT, the Sustaining Judiciary Transformation strategy that I really recognize my lady, the Honorable Acting CJ, drove that process. It's a very good document. It has provision for SMSing so that Kenyans can SMS and find out where their case is. So, you know, there are things to complete the implementation in that strategy. I believe it's under review because it is 2017 to 2021. It's under review. And I think once it's reviewed, then we will be able to correct all the issues there that have not been implemented and begin another process of implementing the new strategy.
Thank you, my lady. Would my lady know the position? Being an insider, would my lady know where we are at with the judiciary fund?
That is the one I was not able to establish.
Okay.
I thought it's in Parliament.
We actually have the law itself.
It's up.
But let's go to the next point, which is this. The judiciary is a big institution present in the 47 counties. And we have that funding of 17 billion per annum. And my lady says that the fines we collect ought to remain with us. Would my lady tell us how that would be done, and go further and say what is the position on tax collection and that kind of revenue collection in the Republic, and whether or what my lady's position is on the economy, on the country's economy, and how that is to be dealt with.
Yes, thank you. I think the solution of whether we can use the revenue collected by the judiciary to put it in our fund is a decision that will involve the entire government because it touches on the whole framework, the whole configuration of how we collect taxes. But in my mind, thinking about how judiciary can be independent financially, I was looking at like the mortgage fund. We got assigned money to give loans to judiciary staff and judges to buy houses or build a house. Once we got that assigned money, it was put in a fund. And then we borrow from there, and then we keep paying at a reasonable interest rate. That fund is almost up and going on its own. because every month people are paying in. Then there are a cohort of applicants who are borrowing, and they are borrowing from that fund. It's actually sustaining. So this is a rudimentary way I looked at, the judiciary fund. Once it's set, if our funds can also go there, then it can actually be sustainable. But that's a big negotiation. I understand.
Yes, and a big discussion, big discussion there.
Yeah.
On whether all the monies can be deposited to the fund at a go, and whether in fact that is possible. Let's go to another point. As my lady leads us in this institution, what does my lady know about the problems, if in fact they can be called that, regarding tribunals in the judiciary? How many are with us? How many are not? And what challenges we are facing there, and how my lady would help resolve them?
Very well. Thank you very much, my lady, Deputy Acting Chief Justice. There are very many tribunals. I don't think I can be able to say on top of my end how many they are. We have the Cooperative Tribunal, we have the Industrial Properties Tribunal.
My lady, the question
Standards Tribunal.
How many are transited, and what challenges we are facing?
Indeed, all of them are supposed to transition to the judiciary, because I think we also have a judgment of the court that has stated that tribunal members and the staff are judiciary staff. So all of them are supposed to transition. So it is the usual business or push and pull, because you are talking of removing power of appointment, power of learning the tribunal from a ministry. So there'll be the usual teething problems, interministerial, that should actually be sorted through negotiations and understanding that tribunals belong to the judiciary. They are part and parcel of the judiciary. So if there are some that have not completely transitioned, is to fix a meeting with the line ministry and say henceforth the tribunal now is answerable to the registrar of the tribunals, who has been appointed by the JSC, is answerable to the CRJ, and is answerable to the CJ and to this commission.
Remaining on that tribunal problem, it's a big one in fact. The responsibility over the tribunals, is it the Chief Justices? Is it the JSC's problem? Whose problem is it? Who should be concerned about getting the tribunals transited? And by the way, what is the role played by the tribunals in the justice system?
Tribunals support the justice system. It's the alternative remedy that is provided for in most of the key areas of the economy. Tribunals are provided so that they are the first stop shop for somebody seeking a remedy. Say the tax tribunal. If you have a dispute with the KRA, then the first call will be the tribunal, because they are specialized, and that is all that they do. The case will be determined expeditiously, and that is the principle behind all the tribunals. They are supposed to deal, the environmental tribunal is supposed to deal with environmental issues before now an appeal can be made according to the way it is provided for in the law, before they can go to the High Court, or if it is a tribunal set on disciplinary of of a judge before I think they can go to the Supreme Courts. So it is the first call where the problems are sieved, and it's a very important forum. So I'll look at a tribunal the way I'll look at a court and say a magistrate is answerable to the registrar of their court, and then the case will go on to the chief registrar, and then it will go to the CJ. If it's a case in a court station where there is a resident judge, it will be the magistrate, the chief magistrate, and then the resident judge, and then it will come all the way, the channels that we use. Now, when we are talking about the tribunal, the chairman of the tribunal will be answerable, will be discussing whatever administrative issues he has with the registrar of the tribunals. And I believe every tribunal will have a deputy registrar as well. And then those problems will be escalated to and there are those which will be going to the Chief Justice.
The earlier part of the question,
yes,
is whose problem it is to sort out the problems or issues surrounding tribunals.
The buck stops at the Chief Justice's office, my lady.
Why? Why not JSC?
It depends on the kind of the problem.
Mm-hmm.
If it is a judicial problem on the decision-making issues, jurisdictions, issues, judicial, it is the Chief Justice. After all, my lady, the Chief Justice is also the chairperson of the JSC. So in his own wisdom, he will know what he can be able to deal with and what needs policy statement from the JSC.
Okay, I hear you, my lady. Let's go to something else, and it is this. Please listen to this statement. It is a fact that the majority of disputes in our society are not resolved through the courts. That is a statement of fact. Now the question is, how do you consider that statement of fact? Is it an indictment of our justice system? If yes, why? If no, why not?
The statement is factual, it's correct. And indeed, that is the way it should be. There is no way the judiciary can solve all the problems in the society. Problems are many. The judiciary is there to be as a matter of last resort. Problems that cannot be solved in the community, in the family, using these alternative dispute mechanisms, using mediation, those are very many problems. Problems solved at the chief's offices, problems solved at the churches, those are many, because I think everybody has a problem one time or another. And no one would expect all these problems to end in the judiciary. Judiciary cannot handle. So it's not an indictment of the judiciary. Judiciary is doing as much as it could and working hard to open multiple doors so that justice can be accessible, especially through the court annexed mediation, through the alternative justice system, empowering communities to be able to communicate with each other and deal with their own problems and solve them.
The next issue for our discussion, my lady, would be, again, a statement. I don't know whether you would agree with it. According to certain feminist legal theories, the law corresponds with or is part of structures of patriarchal dominance and oppression I'll take that again. According to certain feminist legal theories, the law corresponds with or is a part of structures of patriarchal dominance and operation. Does my lady subscribe to that position?
100%, my lady.
Now, please discuss. And as my lady is discussing, let me finalize my question.
Oh.
As my lady is discussing that, let my lady quote to us some prominent cases on the topic. And the last part of that question will come after we have heard the first part of the answer, my lady.
Okay. Thank you very much. The statement is correct that the legal structure is dominated by patriarchy. This is because our society is patriarchal. Laws are made in parliament, and the dominant majority in parliament is male. So it is informed by their background, by their statement, by their socialization, the way they are socialized. They are socialized to look at women as second-rate or second-class citizens, people who are supposed to be at home, homemakers, people who bear children, but are not supposed to take part in leadership positions. That's where we came from all the way from our colonial heritage. So we have come a long way, especially with the Constitution of 2010 that outlaws discrimination. My lady Chief Justice, you will remember even the Constitution of Kenya, the old one, outrightly discriminated against women. They could not confer citizenship. It allowed customary practices to prevail, to be recognized as part of the law. And we know customary practices were those which put down a woman, early child marriage, FGM were not outlawed. But we have come a long way now that the Constitution has even recognized affirmative action and enacted that in all appointed positions in public offices, you must be wary of gender equity in those. So there are many cases on declaring the rights or equal rights of women. The one that comes on top of my mind was a case of a woman, Sarah, I think she came from Namibia, and she went to a hotel unaccompanied by a man, and she was turned away. She sued the Hotel Intercontinental for discrimination, and indeed the courts declared that it was unlawful, it was illegal, it was discriminatory for the hotel to turn away a female guest simply because she was not accompanied by male. So we have so many other decisions on property rights. Women are entitled to matrimonial property which is acquired during marriage, despite the fact that the land was registered in the name of the man who was supposed to be the trustee of the family. We have many in succession law that say that women can inherit property, their status, their marital status, or their gender notwithstanding. So we've come a long way.
My lady, please distinguish, this is important, distinguish between the majority and the dissenting opinions in the matter of the principle of gender representation case in the Supreme Court on the same subject. That's part 2 of that question, and that will deal with the feminist theory.
Yes, thank you very much. The majority decision in the gender two-thirds case was that the provision is progressive. It's the two-thirds gender rule was to be attained progressively.
It was not a unanimous decision, my lady.
The majority decision?
We want to hear the distinct, what you make of the majority and of the dissent.
Yes, I was trying to read the background
Okay.
of what was the majority.
Mm-hmm.
It was the rule will be achieved progressively, not instantaneous. The dissenting opinion was that Parliament is under obligation immediately to enact a legislation that operation to understand that important objective of the Supreme Court. So we are all answerable to Kenyans at the end of the day, but now the court alone must show Kenyans that we are here solidly behind the objective that has brought here, that Kenyans has brought us here to protect and promote constitutionalism, to clarify principles of law and build precedent.
All right, let's get practical here.
Yes.
You get onto the court, and 2 or 3 of your brothers and sisters develop a resistance towards your management style. How does my lady deal with that? We're talking about collegiality here.
Yes.
How does my lady deal with that problem?
I think this is a problem we face on constantly if you are in a position of leadership. I've been a presiding judge in many benches now because I'm a senior judge in the Court of Appeal. I kind of preside every day. And once everybody understands the objective for which we went to court for, we went to court to resolve a dispute. And therefore, when we hear the dispute and we return to discuss, people will have divergent views. I, as a presiding judge, will have to now moderate, and we discuss and see where this one is coming from.
What if, my lady, because I'm talking about collegiality here,
Yes,
I'm not
yes.
talking about judicial independence,
Yes.
which my lady cannot interfere with.
Yes.
Because each judge will rule as they feel they should.
Yes.
Although there's a role to be played there, but it isn't called collegiality. That one has another name.
Yes.
I'm talking about the very coexistence of the 7 of us.
Okay.
And my lady finds a problem of resistance, a problem of a difference in opinion in matters not judicial, not in the determination of the matter. My lady finds an issue with the way each one of us perceives things, in the way that my lady must lead, not just from the front, that's a tired phrase, but lead in such manner that to the greatest extent possible, the court is a team. So I'm looking for mechanisms of solving differences between just the 7 of us and getting us to move as a team. And the question has been, what has prepared my lady for that, and how would my lady resolve a situation like that? My lady must agree that if you are not working together to the greatest extent possible, that discomfort could translate into the efficiency of the court, right?
I agree. I agree because there are too few not to gel and work together. So if there is disharmony arising out of people's attitude towards my leadership, we will call a meeting, we will go on a retreat. And depending on the magnitude of the problem, we can even ask a facilitator to help us in the discussion, because always when people talk together, issues come out. What are the reasons that make my colleagues look down upon me and resist, like my lady you have put it, resists my management style? And what is the management style? Judges are completely independent in the way they make their decisions. Nobody can tell them decide like this and like this. So the disagreement is the work. Is it the work days? So we agree. We all know Supreme Court cannot sit every day. Even the Court of Appeal, we don't sit every day because we have to give room for writing judgment, very heavy duty judgment that require a lot of research.
All right.
Is it because the days are not agreeable, the cost list is not agreeable? Is it that they don't have secretaries, they don't have the work where or whither? So we find out the problems, discuss the problems, find the solutions, joint solutions, and from there we say let us join hands because of the objective that has brought us as Supreme Court judges. Let's own that objective, the mission and the vision of the Supreme Court.
All right, my lady.
And be accountable to Kenyans.
All right. These three are my last questions. The first is, and this is on the court now, what is the place of stare decisis on the mandate of the Supreme Court? The second one, what is my lady's position on a dissenting judgment? And the third question will be, my lady, is my lady aware of any, or are there in fact any amendments, recent ones, on the Act, the rules? And if my lady is aware of those, what would those be? And I wish you well, my lady. Just give us those short answers to the three questions.
Yes, indeed, they are very short because stare decisis, so the principle of precedent, is one that is founded in the Constitution. I think the article that creates the Supreme Court provides that the decisions
if my lady didn't read the Constitution now?
Okay. I just wanted to get that particular article.
No, just give us the import.
Yes, the stare decisis the principle of precedence, and it has been constitutionalized under our Constitution that judgments, decisions of the Supreme Court bind the other courts below. So the decision of the Supreme Court will be binding on all the other superior courts and even the subordinate court. That is the principle.
And on the court?
On the court cannot be bowed forever because circumstances change, socioeconomics change, things are always shifting. So the court can always depart from its own judgment because this is the apex court. You can't stick to a position that has become redundant because the society has progressed and things have changed. So they have a leeway to depart from their own judgments. My position about dissenting judgments, these are very powerful tools in the development of the law. When a judge feels strongly that This is my view of the matter. And let me put my thoughts on the paper. Sometimes that dissenting judgment has actually become strong because of the circumstances. It is sometimes very futuristic because the judge who writes a dissent is seeing to the future. And whereas these others may be just concentrating on the problem at hand. So we always celebrate a dissenting judgment because it opens up the space, allows people to express themselves. Amendments on the rules and the Supreme Court Acts, I'm sorry, I have to look out to that at the Kenya Law reports.
Thank you. No, we have the amendments here. We already have them gazetted and everything. They are available right here.
Okay.
I wish you well, my sister.
Thank you very much.
Thank you very much, Honorable Judge. I will now request Commissioner Judge Majaja. Oh, sorry, Commissioner Judge Warsame. Ask questions.
Thank you, Professor. Judge, let's start with Article 45.3. Parties to a marriage and the equality of rights. Does marriage per se give one of the opposite parties propriety rights, and why?
Parties to a marriage and equality of rights to the property. It depends. If I got married today, I have my property. My spouse will not be entitled to my property. The property I had before marriage, that's my property. So, and vice versa.
So the
if it is
point
a man and he got married to a lady, when he already has property, that is his property.
So
but when the lady comes into the marriage, let's say it's a house, and they develop it further, and put developments, they live in it for many years. She of course acquires, occupational rights. Yes.
So per se, marriage does not entitle one of the parties propriety rights. It's not a propriety relationship.
No, not in the instance. But once you live in it, and you create other relationships and other rights within it, then those rights can be claimed. Okay. But as you're entering, on the entry point, it doesn't.
Okay, my Lord, tell us 3 problems you will solve in the Supreme Court. 2 problems you will solve in the High Court within your next 30 days if, God willing, you become the Chief Justice of the Republic of Kenya.
Thank you, my Lord Justice Warsame. That is a tall wonder because I haven't even known what problems are there in the Supreme Court for me to say I will solve them in 30 days. 30 days, I think, is a very short time for one to carry out an evaluation of the existing institution and, identify a problem and begin the process of solving. I know there is endemic problem of backlog of cases across board, to a little extent also in the Supreme Court. Maybe a low-hanging fruit is to say, let us do a service week in the Supreme Court to list the matters that are pending, the ones which are owned, and see whether we can reduce them maybe by 30% within 30 days. But like this is a Supreme Court which is established. So one has to, first of all, meet the judges, meet the registrars, identify what is the problem, agree what is the mode of resolving these disputes. So that is the Supreme Court. Did you ask about the Court of Appeal or you went straight to the High Court?
I went straight to the High Court.
The High Court also needs to meet with the leadership of the High Court, the principal judge, discuss what is the most urgent and immediate problem that can be addressed within 30 days. And the one that comes on top of my mind is how we can also have a service week in the area which is most urgent. The principal judge will be able to tell me whether it's a criminal, that the criminal division is really and reduce them by a significant percentage.
Okay.
Yes.
One of the court, in my view, that has lost its identity is the commercial court, which was meant to ensure that the process of resolution of dispute is efficient, effective, and within the shortest time possible. How will you address that problem?
Yes, that is a very important question because the commercial court deals with businesses, deals with investors, and we need them to have confidence that when there's a dispute, it will be resolved expeditiously. So within the commercial court, we will look at multiple ways of resolving disputes other than through a hearing. There is mediation. And you know, commercial transactions really begin with an agreement. People who entered into an agreement can always sit down and resolve the problem arising out of the agreement. So mediation, ADR, alternative dispute resolution, jump starting it, we'll see why things are going to clog the courts when they ought to go that way. And also embracing a case management system where parties file their documents and then there is a call over before the case is fixed for hearing. Documents are agreed upon. So when you go for hearing, you don't even spend time on the witness box other than if there is an issue to clarify. You just adopt the documents, you adopt the submissions, you leave the matter to the judge. The work is a lot also on the judge, but see how their capacity can be enhanced for them to work faster now that we have researchers. Develop some work tools and systems that assist the judge come up with a decision quickly. You have a template, what goes in the template, what the researcher information is supposed to bring and arrange, what the secretary is supposed to arrange. To discuss with the principal judge, and the judge is working there to see how they can unclog the system.
Worked there and I worked there during Gisheru's time. If you are not delivering, you could not be in that court even for 6 months. Is there, how will you deal with the manpower to ensure that court satisfies the intentions why it was created in particular?
Yes, I agree, my Lord, that there could be a shortage of judges there, just like there's a shortage of judges across board. But even looking back at when we worked there, we were not very many judges, but I think we were able to bring the backlog of cases to, I think the oldest case would have been like 3 years when we worked at Milimani. So, which is still a long time because I ran the judiciary transformation, the sustaining judiciary transformation strategy and the reports. The backlog should be a year. So, but this approach of case management I don't know whether it's completely internalized and operationalized at the Milimani Commercial Court. So these are discussions to have with that court to see where is the cog, where is the hindrance, why aren't we discussing this, because every judge should also have their own docket. Like, for instance, when I went to Nakuru, there were so many cases. So we counted all the cases and divided them among the 3 judges. And subsequently, when a case was being filed, a new one, it was number 1, court number 1, number 2, court number 2, 3. 1, 2, 3. So all of us had equal number of cases. So if one judge is not performing, that will come out in the performance management, measurements, and also in your daily returns. So then you can do peer review on this one who is not performing. Say, look, you are bringing us backwards. Please pull up your socks. You ought to have finished 12 cases in a week. You are not finishing that. So, these are management, operational issues of how to effectively run a division.
Okay. The position I take is that currently the judges or the judicial staff are well resourced in terms of money, salary, and everything. Unlike during Gisheru's time, we have legal researchers in the High Court, Court of Appeal, and in the Supreme Court. We were very few then. We were around 42. But there was a lot of efficiency. But now we are almost 200 judges, and there's a lot of backlog. What is the problem, and how do you intend to solve?
Yes, this is a problem across board. And I look back because I was previously and also in the divisions. We were very few, but somehow we managed. Now we are so many, we are not managing. So that is an issue to interrogate. Is every judge having their own docket of cases? Or is cases all in the conveyor belt going today, Judge A, B, C, D. Tomorrow they turn around, what was in number 3 comes to number 1. So it is turned over generally. Another tradition we found, which we worked against. So it is to examine those systems and see, because the one that works in my view and the one that I would be projecting and selling out is a case management system where somebody owns their docket from the beginning to the end, so that this file will not be before me today, tomorrow before you, my round, to the other day before another judge. These are always my file from the beginning to the end.
Okay, now let's discuss 3 areas. You said that you have not analyzed whether any problems in the Supreme Court, but I is the case of Muriatetu. And the question before the Supreme Court was whether or not the mandatory death penalty is unconstitutional. But the court created, in my view, 3 problems which you need to solve. The first one can be found, and you see correctly also, to their credit, the advocates appearing for the petitioners, Mr. Ngati, a senior counsel, and Kilukumi, I thought also is a senior counsel, they raised only 2 issues in their submissions. But the judges captured what was the issue. And they said whether the mandatory nature of the death penalty and the 204 of the Penal Code is an attempt forcing the trial court is against the principle of fair trial. Those were the two issues which they raised in their submissions. And the first one, they dealt with the issue of life sentence. And this is what they said, my lady. We acknowledge that Kenya and internationally sentence should not only be used for the purpose of retribution. It is also for the rehabilitation of the prisoner as well as for the protection of the citizens who may be harmed by some prisoners. We find the comparative jurisprudence with regard to interdeterminate sentence is compelling. We find a life sentence should not necessarily mean the natural life of the prisoner. That is one of the first issues which they have created. And they said it could mean a certain minimum or maximum time to be set by the relevant judicial officer along
you have a problem there. Just 1 minute, we solve the problem of the microphone for the judge. If this is working, maybe Judge Osaba, you could kindly come and ask from here. Sorry about that.
Sorry. Sorry, Judge. And as I was reading, Judge, they said it could also mean a certain minimum or maximum time to be set by the relevant judicial officer along established parameters of criminal responsibility, retribution, rehabilitation, and recidivism. That is also the second problem which they have created, which was not part of the issues that was set for determination. In essence, they were saying in this judgment, life sentence does not mean life sentence. It can be interfered with by a judicial officer. And lastly, the third problem which I see is this. The Attorney General, the Director of Public Prosecution, and other relevant agencies shall prepare a detailed professional review in the context of this judgment and order made with a view to setting up a framework to deal with sentence rehearing cases similar to that of the prisoners herein. The Attorney General is hereby granted 12 months from the date of the judgment to give a progress report to this court on the same. And then again, they say, we direct that this judgment be placed before the speakers of the National Assembly and the Senate, the Attorney General, the Kenya Law Reform Commission, attended with a signal with utmost urgency for any necessary amendment, formulation, enactment of the statute law to give effect to this judgment on the mandatory nature of the death sentence and the parameters which ought to constitute the imprisonment. Those are three problems which is awaiting your resolution. How do you intend to solve them?
Yes, thank you, Myron. Thankfully, I've written an essay on the Muruatetu case, and it's part of my sample writing that I shared with the Honorable Commission, which shows that I'm acutely aware of, I would call operational problems that arose from that decision that affect the criminal justice system, and they need to be fixed. The judgment was profound. It was groundbreaking. In one pronouncement, that sentencing is judicial authority to determine the proportionate sentence is the discretion of the magistrate. However, death penalty is still a provision in our law, and it still remains. But death penalty as the only penalty is unconstitutional because it takes away the role of the judicial officer to determine the appropriate sentence to give. And the reasons are very well stated in that judgment, and we all agree with them that not all murders are the same. Some of them are grisly. Others are somewhere there. They are not manslaughter, but really you can see the violence that was met. Or the best example is robbery with violence. Not all robbery with violence are the same. Walking down here, some youth, 3 of them would like to grab my chin. They threatened me with a stone or something to beat me, and then they ran away with my chain. That's robbery with violence. And there are other robbery with violence where people come with guns, terrorize a family, rape, cause mayhem. That's also another robbery with violence. So when it comes to sentencing, before the magistrate would say, my hands are tied. This is a simple robbery, but it attracts death penalty because the ingredients of robbery with violence are present. The perpetrators were more than one. They were armed with a dangerous weapon. Never mind, it was something not really that can inflict. It's a knife, but they never even used it. But the victim felt threatened, and they robbed. So in that sense, it helped the justice. so that judges, magistrates can mete out proportionate judgments according to the circumstances of the case. Now, that judgment opened a Pandora's box by saying all those people who are sentenced to death apply for review, and also directed the Honorable Attorney General to come up with a policy and eventually the Speaker to amend the laws. This is our country. These are our problems. We have to solve them when they occur. So for me, immediately what I can do is follow up with the Attorney General to see whether that sector-wide report on sentencing has been prepared, to inform also our sentencing policy, so that our sentencing policy now takes into account the recommendations from the Supreme Court, so that, but having worked with the Muruateto in the Court of Appeal, we have also held this view, and I believe you are one of them, including my lady, the Acting Chief Justice, that this matter perhaps needed to be mentioned in the Supreme Court for certain clarifications. For instance, you mentioned a life sentence. What is life sentence? Is it 20 years? Is it 15 years? I think the Supreme Court would do well to define for us what do we perceive to be a life sentence. I think in the Court of Appeal, the trend is anything 20 years is a life sentence. But we need a coherent, coordinated approach to sentencing, and that is actually what is contained in my paper, which I prepared following a request from the President of the Court of Appeal. We had a whole week dealing with the matters where accused persons were sentenced to death, and they filed the appeals in the Court of Appeal, and then they have gone to the magistrate court where they were tried, and they have sent revision, and their sentences have been revised. When that sentence was already affirmed by the High Court, and the Court of, and there is a pending appeal in the Court of Appeal. So we go to do appeals, they are called, and we were told they were released. You know, that looks like a backdoor release, because once the sentence was affirmed by the High Court, there is no way you can go back to the magistrate court. So there is a lot of instability in the criminal justice system. So when I'm Chief Justice, we can look at the Muruateto case again and core parties to mention and discuss those issues and see whether clarification can be given, because this is the apex court that should give directions to the other courts. And then the law reform, of course, should be involved, the AG and the public stakeholders, because this is a matter on criminal justice. And also we review our sentencing policy.
Okay, so you will agree with the school of thought that says the Muruateto has created unpredictable, disruptive, and uncertain interference of courts against its sentences lawfully provided and lawfully imposed.
Thank you, my lord, but I don't think I would use that those strong terms, because I have already discussed how helpful it has been in helping the judges to determine a proportionate sentence to give. But there are other problems. It needed to be monitored. This is actually one judgment that needed to be brought for mention again before the Supreme Court within 3 months, so that the problems that were arising out of it, because this was a murder case. This was death penalty as provided for a murder offense. But through parity of reasoning, and you can't stop judges from exercising their minds to compare situations. It has been used for robbery with violence, it's been used for sexual offenses. Really, we are at a bad place in the criminal justice.
In your just one of your sentence, you said sentence a judicial authority and the judge or the magistrate should impose the appropriate sentence. In the circumstances of what the law provides in terms of minimum and maximum sentence, in all our statutes, both in the Sexual Offences Act, both in the Narcotic Act, both in the Anti-Corruption Act, the Mutudo Act, and many acts, they provide for maximum sentences, maximum and minimum sentence. What is your view? Does Murietetu apply to Sexual Offences Act?
My Lord, as you know, we sit within the Court of Appeal. We know it has been applied in sexual offences. And there are situations where I've agreed that it comes in handy to determine the proportionate sentence, especially where it's a case where there was no violence, there was consensual sex between the victim, and their age difference is not huge. Let's say the boy is 19, because we don't have a youth justice here in Kenya, and we need a youth justice. You cannot graduate from being a child at 18, and when you're just 19 and 20, you are dealt with strange hammer of the law. We need to nurture our youth. That is a failure of our system in the society. So in these cases where there was no violence, it's a Romeo and Juliet case. The age difference between the victim and the perpetrator is not huge. They were girlfriend, boyfriend. I've seen the Court of Appeal reduce the sentence to, say 5 years, or, depending on the circumstances of the case, a slap on the wrist on the perpetrator.
Okay. Now that we are discussing the Murietetu case, I just want to finalize. Do you think the problem is the High Court, Magistrates Court, and the Court of Appeal interpreting the judgment of the Supreme Court? Or is the problem the Supreme Court? Again, 3 years down the line, the Honorable Attorney General, the DPP, and both speakers have done nothing in terms of implementing the judgment. So where do you think is the problem?
Thank you, my Lord. I think the problem is all of us, the society, and we have to depart from, I think the Constitution requires us to stick to the values of consultation, participation, negotiations, reaching out. So we need to reach out, because I think the buck stops at us as the court. It's the court that is being projected as the one which is not functioning, or which is not coherent in the way we are doing our things. So we need to take it up. And when I'm Chief Justice, I think the first thing I would do is issue a practice direction on how Murietetu should be applied. And I think, I believe my paper, which I've shared, has some policy recommendations.
Thank you, my lady. The second issue which I see a problem, which you need to solve, is the debate about substantive and procedural justice. One of the issues which you need to resolve is the issue that has confronted the Court of Appeal and also in the Supreme Court, about where to file the notice of appeal in election matters. And I have a particular case here, the case of Musa Sirma, where the notice of appeal was filed at Kaparnet, where the trial took place. But the judges took the view, the Court of Appeal judges took the view that this was not filed at the appropriate registry. The Supreme Court, addressing its mind, also agreed with us. What is your view on that debate Because I know even us in the Court of Appeal were divided on that issue.
Yes, thank you very much. I think the Constitution gives us the command that we should always aim at doing substantive justice as opposed to looking into the procedure. But we all know that the procedure is the one that feeds the substance. And the procedure is the one that brings predictability, because I know if I have this kind of a problem, I will follow this procedure, and then eventually it will lead to substantive justice. And I belong to this school that asked, was the notice of appeal filed? Was it filed timeously? And I would overlook the fact that it was filed in Kabarnet Court as opposed to Nakuru or whichever the High Court that was hearing the petition. So like you say, this is undivided opinion, but since we are reviewing our positions before the next elections, these are matters which will be discussed by judges, and they come up with one common ground on the way to move forward in future, because perhaps it was not a mistake that they found in Cabernet. If that is where the case was handled originally, they probably overlooked the provisions of the law. We always say that ignorance of the law is never a defense, but you know, we encounter these problems every day. Depending on the circumstances, we allow when we are looking at the bigger picture, which is justice.
Thank you very much. And lastly for me, my lady, is I don't want you to comment on the merit of the case, but what you will do as a Chief Justice of the Republic of Kenya. The recent case of the BBI, where the Supreme Court, where the several cases were filed in the High Court and other cases were filed in the Supreme Court, I think by December or November, something like that, and the case was mentioned several times. But lastly, there was a ruling delivered by the court on the 16th day of March 2021 saying, let the matters in the High Court be resolved. There is a school of thought that says, since the Supreme Court confirmed that this was a matter of great public importance, the High Court does not have jurisdiction. And it is only the Supreme Court that has jurisdiction, and that it was not right for them to refer the matter or to stay the matter pending the resolution of the High Court matters. What will you do? Because this is the apex court, and it must lead in terms of jurisprudence, and it must lead in terms of issues affecting the country. What will you do if you are the Chief Justice?
Thank you, my lord. Those are very turbulent, sensitive matters because they are live. I cannot really discuss them because they are sub judice. But since you have cautioned me not to go to the merits of the case, I'll just tell you what I can do. If these are matters of general public importance that affect a close section of Kenyans, I will read those files. We will call a conference of judges of the Supreme Court and discuss whether the Supreme Court takes over all the matters that are pending in all the courts and hears the matter. That will be, you know, a discussion arrived at from a participatory and consultative forum of the judges of the Supreme Court.
Sorry, this is my final question, final question, I'm sorry. And I just forgot to ask a question that has been given to me by the Commission. How will you resolve the dilemma of the 41 judges? And this is a standard question for all candidates.
Thank you very much. This one must be resolved. Like I said, through negotiations. There is one major problem I see with perception of what is judicial independence and what is interdependence. Because we are independent. The judiciary independence is secured in the Constitution. And nobody can claim to take it, and nobody should attempt to take it because it will be unconstitutional. But the judiciary is accountable. They go hand in hand. And the judiciary is interdependent because we all serve Kenyans. The executive serves Kenyans. The legislature serves Kenyans. Therefore, when the right hand doesn't know what the left hand is doing, or is not agreeing with what the left hand is doing, the body, which is now the Kenyans, are suffering because of the standoff. So when I was preparing for this interview, I know of the National Council on the Administration of Justice that brings all the actors together to discuss coordination of the administration of justice. I've also read the Intergovernmental Coordination Act that makes provisions on how the central government relates with the county governments. And there is a whole act of parliament complete with the mechanisms of how to deal with stalemates and standoffs. When I looked at the judiciary, we are interdependent as far as the delivery of service is concerned. And that's our core business, delivery of service to Kenyans. We get our money from the consolidated fund. We are part of the government. So we need to explain what is interdependence. Where do we come together on matters of administration of justice? The human resource, the capital, the budgets of the judiciary, the infrastructure, all those are projects that involve everybody. So we need an act of parliament operationalizing the NCAJ, and therein a mechanism for resolving any standoffs. Regular meetings with the executive, with the legislature, so that when the CJ is seen with His Excellency the President, people do not think that they are discussing a case, because our independence is in decision making and in hiring. The other things, we are interdependent. When the CJ is seen with the President, they are discussing matters on administration of justice, that everybody is responsible. It's not a beautiful.
Welcome back, Commissioners. Welcome back, Honorable Judge Koome. We will continue with our questioning, and I will request Commissioner Honorable Majaja to continue. Thank you.
Yes, good morning, Your Ladyship. I just want to continue from where my brother left. And you talked about the 41 judges. One of the issues of concern, of course, is you say you will adopt a strategy. How would that strategy be implicated? Because one, nomination, the advice is the advice of the Judicial Service Commission, not the judiciary, number one. Number two, we have had 2 court decisions over the same problem. We had one years ago, and the same decision was re-emphasized. So, as the Chief Justice, how would these 2 factors implicate the approach you use?
Thank you, my Lord, Commissioner Judge Majanja. The strategy I would use is what I was explaining before, is a missing link between the agencies that are responsible for the administration of justice. There is no mechanism that brings them together to resolve any problem that comes about in the administration of justice. And I recognize there is absence of a law that governs the National Council on the Administration of Justice. It was anchored under the JSC Act, but now it's such a big body, a huge body, with so many actors that it needs its own act of parliament. The judiciary has done well to nurture it up to where it is, because it's under the JSC. The CRJ is the secretary, the CJ is the chairman. But it has reached a point where we need a mechanism for resolving disputes. And nothing stops parties from negotiating a case, even post-judgment.
Okay, so suppose tomorrow when you become the CJ, one of the problems you'll be dealing with is the vacancies in your court, am I correct? It is one of the things that will be concerning you.
Most urgent.
Yes, so as the CJ, what would you do to prevent that problem from recurring?
I will pick up a phone and fix an appointment with the appointing authority to go and discuss, even with members of the JSC, the state of the administration of justice. It's a concern for everybody. And through discussions, you identify what are the problems, how those problems can be resolved, because we are all Kenyans, we are answerable to Kenyans. The one who wants to access justice is suffering. So this problem cannot just belong to the CJ, it belongs to all the people. So when we come to the table, we will find solutions. I'm very good at negotiating and persuading.
Okay. Now I want us to talk about accountability. There is accountability of the individual, accountability of the institution or body. You have given us a good account of your performance in the High Court. Very impressive, I must say. And I remember watching your interview when you were interviewing for the Court of Appeal, and no one can be failed to be impressed by it. However, when you go to a multi-member court like the Court of Appeal, how is individual accountability to be assessed by members of the public?
Yes, a multi-member court like the Court of Appeal, you cannot assess the performance of an individual member alone to the public, because you work as a court. In fact, we are evaluated as a court. The overall evaluation of the Court of Appeal, the overall evaluation of the Supreme Court. But the president is able to know how many judgments are pending. Okay. And the president will call the presiding judge and ask, why didn't your bench deliver this judgment? You are the presiding. So the presiding judge answers to the president. And then it becomes necessary, if one judge is not generating the draft, then you call the judge who is not generating.
Yes, that
and you peer review and you agree.
So so there is the account, like for example, you were in Nyeri, you did a good job. You were in Malindi, you did a good job. But for the public, how are they to tell merely because you sat in Nyeri with 2 other very competent judges, 3 competent judges, that you are the one responsible for the output. Because you are 3, and we want to see just the way we are assessed in the High Court. If I go to, like you are in Kitale, for that 1 year we can say, yes, you did a good job. So I want us to focus on the individual, because it is the individual we want to judge.
Okay.
Yes. So what is it that, how can we judge the individual judge in a multi-member court?
Thank you, my lord. I think you judge the 3. The success belongs to the 3. It cannot just be one judge who delivered. It is the bench. It is those who are judgments and the rulings of the bench at Nyeri that comprise the Honorable Justice Vislam, the Honorable Late Professor Ondek, and Martha Koome.
Okay. Now, you see, we are supposed to make a choice of who amongst these judges is to go to the Supreme Court. So, we are agreed with you. You've done well. But you know, moving to the next court also we have to assess the intellectual heft of the candidate, isn't it? You agree with me? And it's not only for the JSC here, it is for the public, because that's what accountability is. The public must be able to see the court. And as I said, these are multi-member courts. You're saying you wrote them, but you see, for the public, we have no idea. We see 3 names there. So how are we to judge you that you are the intellectual leader and therefore deserve to move forward?
I don't know whether I can say this publicly, but when it comes to giving sample writings, my conscience will not allow me to give a judgment that has been generated by somebody else. So the ones that I gave are the ones which I was tasked with the responsibility of generating. And then because the others agreed with it, there was no need for them to write separate ones.
Yeah, because you see, that is what we may perceive, but see, for the public, they don't know.
Yeah.
They're just saying that court, Court of Appeal, always delivers judgment 3 people. So for example, if the public were to ask, this is the Court of Appeal, tell us who is the intellectual giant in the Court of Appeal. What would you use as a metric for measurement? Because as a JSC, that is what we are supposed to ask ourselves. Is Judge so-and-so up to the task of being the intellectual leader? And we look at your judgment. So you say, this is my one judgment where I delivered. And the public should be able to see, this is my one judgment where I delivered.
Everybody in the Court of Appeal is an intellectual giant, but speaking for myself, I'm an intellectual giant also. Speaking for myself.
Yes, but in the Court of Appeal, you are content to be together with the others, hide with the others, so that you just do the same judgments, all of you together, isn't it?
I do not do that. When occasion demands, my Lord Judge, I write my own dissent. Yes.
So, how many dissents have you written?
I've written several. I've written a couple of them.
And those the ones you were supposed to tell us, this represents, and by the way, when you asked about dissent, you made a very good suggestion. You said it's futuristic, it is something. So, don't you agree with me that in fact those are the ones who would have been happy and the public would have been happy to see?
Well, on insight, if that is what the expectation of the commission was, maybe I missed the point, but if you go to Kenya law and tap my name, and many judgments will pop up, even where I've written a dissenting opinion will pop up.
So, on that issue, don't you think it is the time multi-member benches, for purposes of accountability, to insist that judges write their individual judgments?
It's really a very good idea, my lord,
Yeah,
for
because
every
I've looked-
judge to write separate judgments. But look at the capacity of that court. Only 12 judges hearing appeals all over the country. Because when I say 12, you know, my Lord Justice Wasame sits in the commission.
No, I understand.
The president has administrative law.
Yes.
My Lord Justice Kadurima is at the JTI and now at East Africa. So we are left 12.
Yes.
So 12 traversing the whole of this country and each writing a judgment in a matter, you know, the ordinary matters where we have not disagreed on anything. We are in agreement. We all went to court. We conference before going to court. We went to court. We had the matter. We came back. We conference. And we are all in agreement. This appeal is for allowing.
Yes. That
Now,
is why.
expecting each judge to write their own draft in all those matters, I think it's at all under,
Yes.
even in terms of judicial time.
Yeah.
So when the capacity is enhanced and all the systems are working, technology is working, researchers are in place, they are there now, but they need training because they were newly recruited. When all systems are working, we can expect every judge to write their own.
Yes. And you know, I have looked at other intermediate court of appeals, for example, I was just checking in Tanzania,
Yeah.
where actually it is one judge who writes,
Yeah.
and then the other said, okay, we agree. So you are able to see that this judge is consistent in this way. They are not, you can be able to judge somebody by what they are able to do. So that is something I think one has to reflect on, because if you're all writing the judges together, then the issue of accountability is lacking. And for me, when you present the judgments as they are, then I have a problem. Yes. And it is something that is... so what is the responsibility of the one judge? The one judge, you are three. What is your responsibility in terms of that accountability, both to the public and yourselves?
A judgment is issued which gives reasons, justification. Because I'm part of that judgment, I read through it and I make my comments before the final draft comes out. We could be having even 3 drafts, because I'll get the draft, I'll get the file, and I'll put in my input. The other judge will do the same. They will be corrected, and sometimes we call another conference. So by the time the judgment is being issued, you all agree this is what we wanted. It has come out. We own it.
Yes. And that would not be difficulty. For example, they said, Mother Koome JA, this is the judgment, and we all agree. Would there be any difference?
There wouldn't.
Yes.
Yes.
So that is an issue of accountability.
Yes, and because JSC is responsible for the independence of the judiciary and accountability, when we go to the conference of judges, this is something to throw on the floor for the judges to adopt.
So that brings me to the judgment of the court, because it is the judgment of the court,
Yes.
one of Communications Authority, and Okia Omtata. You remember that decision?
Yes.
You delivered the judgment on 24th of April?
Yes.
Yes. You recall what happened thereafter?
Yes.
What happened?
There was a backlash.
Yes.
And this is why I brought it, because it brings out the issue of communication to the public.
Yes. So there was a backlash. In fact, they said, if I may just paraphrase, they said the court allows the government to tap phones.
Yes.
Yes. So there are 3 things I want to put to you. 3 things, and answer how you would resolve them. 1, the court was not very clear in its judgment. Maybe somebody read and they misinterpreted. So that's 1. Number 2, the court is not alive to the manner of communicating this kind of issues in this day and age. So maybe you deliver your judgment and put it in the folder, and you leave everybody to say what they want to say. Number 3, maybe you did not communicate the outcome properly. So first of all, which of those 3 led to that kind of a situation?
First of all, the judgment is very clear that the judge was wrong to say that the communications authority breached the rights of Kenyans by allowing that system, DMS, which was to tap communications. That was not founded on the facts before the case.
Let me just stop you there. Fine, the judge said what he said.
Yes.
My position is, and the question I'm asking, you see, you can write all that. So the issue I'm asking, I relate to you three scenarios. You have said one, that the judge has, the judgment was very clear. Maybe that's not what the public read. Maybe that's not what and we have had those situations. Even on Sunday, I believe there was a judgment of man and they said something else. So what I want you to tell me is those three situations, what is your solution? What is your solution?
Very good. This is establishing a communications department within the judiciary that communicates judicial decisions to the public. Because I think we have to look at the capacity of the existing departments and see whether they have capacity to decipher what is the ratio, what is the determination, and what are the final orders. And only that we are so constrained in our court in terms of room and resource. Every time we have met as a college of judges of the Court of Appeal, we have said when the court is issuing a decision that has a public interest connotation in it, there must be a brief to the press, a summary of this was the case and this was the decision of the judge, the ratio, and these were the orders.
But let me stop you there for a minute. Can it be argued, for example, that actually the burden is on the court to explain those issues very clearly so that any Kenyan doesn't need a second document to tell them what is it the court was trying to say, what is the ratio, what is the obiter. I mean, shouldn't the judgment just, if you put it out there, isn't that the obligation of a court, particularly as you go higher, your burden becomes higher, that you're speaking to the public? Isn't that something?
Yes, that is the way it's supposed to be.
Okay.
But you know, because of COVID, we are challenged completely. Right now, we are issuing our judgments online. There is even no interaction with the public. They are being issued online.
Okay.
But we are perfecting our systems. We are perfecting our procedures. We are embracing the best practices. So this is work in progress.
Okay.
And also bearing in mind the constraints.
The second issue, the social media got ahead of you. How do you deal with that?
Yes. So we also need our social media, which is activated as the Court of Appeal. I don't think we have these handles that I see being used, the Twitter handles. Those I think are for the judiciary. The Court of Appeal doesn't have. So those are things to look into so that we are also transmitting information, simultaneously with everybody else.
And that brings me to the case of Caleb Khalifa. You remember that case?
Yes.
And you know it has been the subject of a complaint.
Yes.
Before the JSC, that complaint was dismissed.
Yes.
Maybe very briefly, tell us what you understood the complainant to be complaining about in your own words.
The complainant was complaining about a sitting of the Court of Appeal that happened the day before the repeat of the presidential election in 2017. What happened, a judgment was issued in the High Court declaring that all the returning officers and their deputies were illegally in office. An appeal was filed. My lord, the Attorney General, was the president of the court then. I was working in the bench in Mombasa, Marindi. But as you all know, the Court of Appeal is a circuit court. Even if you're in Mombasa, in fact, we used to do 3 weeks in Mombasa or 3 weeks in Nyeri and come to Nairobi 1 week because the backlog of cases was in Nairobi. So that particular week, we were all in Nairobi to do an RRI exercise. And therefore, the day before that election was a public holiday. I was called by the registrar, Mr. Selem, and I believe you have asked him questions here when you are determining the dispute, and told that the president has said, has certified a matter urgent, and has sent the bench comprising of Justice Givenji, Sishare, and Koome hears the urgent application. We should not lose sight that this was a determination of an election which is taking place the next day. Presidential election which is taking place the next day. So
you were called,
urgent,
you sat,
I was called, I came.
You came. This is the case. Complaint is this. When you sat, you had one advocate before you.
Yes.
Isn't it?
Yes.
You as a member of that bench, did you, for example, ask where is counsel for the other party?
We did ask, but we were told, and the counsel argued, the matter is very urgent. There is no time to serve because the elections are taking place the next day.
So it was about how?
So it was an ex parte application.
Okay, it was an ex parte application. Under the Court of Appeal rules, and do we have ex parte hearing of ex parte applications other than applications for urgency?
There is, when the justice of the matter requires, the overarching objective in the administration of justice, that you use your discretion to see where the justice of the matter lies. And that is the one we used.
Okay.
And to see that tomorrow is the day set by the Constitution for the election. And shouldn't they happen, there was going to be a constitutional crisis. The matter before us, what does it say? It is touching on the presidential election. We all know the presidential elections disputes are handled by the Supreme Court. And my lord, I think the Supreme Court determined that matter and said it is the one that has the ultimate jurisdiction.
Yes,
to determine.
I understand. All I'm concerned about
is
that it does not appear, and this is critical because it does not appear either from your decision that you even inquired and said, because in this day and age you can pick up the phone and call. Remember the judgment had just been delivered that day. There was nothing difficult about telling the registrar, can you call Mr. So-and-so who appeared to come and deal with the matter. There is no indication on the record. There is no indication in the decision. So you can understand a litigant who is horrified and who is accusing the court of doing its own things, isn't it? So what was the difficulty about just saying midnight or 1 hour, can you call Mr. So-and-so? Just the way you came here to call and come. Was there any difficulty?
You see, my lord, this was an ex parte matter. That is what we understood. The presiding judge was Justice Givenji. I believe we discussed the matter. We discussed whether parties were served, and we discussed our jurisdiction to make an interim order, and we found we could make the interim order.
So that is why I've been asking. You see, you are in a multi-member bench.
Yes.
And it is your responsibility to say, okay, we are here, 3 of us, but have we served the other party? Because that's a serious issue, and we have even dismissed magistrates for failing to do that. And you know, as the Chief Justice, the days we are going into, who authorizes the court to sit after hours in the judiciary?
Well, it is the presiding judge, the president of the court, under the Court of Appeal Administration Act. It is the president of the court who constitutes benches and who prepares the course lists. So when the president of the court certified the matter and constituted the bench, said the matter be heard today because of the urgency, it is him I'm answerable to.
Don't you have an obligation, for example, to ask, has the Chief Justice authorized us to sit after hours? What is your responsibility?
As long as the president of the court had already prepared the course list, empaneled the bench, called me to sit, and I myself, using my own discretion as a judge and a senior judge, appreciating that this is a matter of national importance that requires an intervention, I knew when we are dealing with presidential disputes, everything is urgent. You saw the Supreme sitting through midnight.
Yes.
So this was a matter extraordinary circumstances which do not occur every day.
Okay, so they don't occur every day, but first, so we don't know whether the CJ authorized. 2, we know that the other party was not called, or rather, as a judge, you did not ascertain. Now, then you make the decision. Are you aware that, in fact, this decision is not even on EKLR, the decision that you made?
I'm surprised it's not on EKL because all the decisions of the Court of Appeal are transmitted, and it's not me who transmits. We have an office of the registrar that is the one responsible for transmitting to EKL.
Yes. But you can see why somebody has a valid complaint that justice was not seen to be done. You understand why?
Incidentally, that matter is seen 2 ways.
No, I'm just saying, 1, you don't call me. You don't call me. 2, you make the decision. He says, look, the CJ should have authorized, he has not authorized. 3, you make a decision, which I never get to see. Is there a basis for a valid complaint for somebody to say justice was not seen to be done?
In fact, it's today I'm hearing that.
Yes, and that is why I keep raising the issue of accountability of a single judge in a multiple bench. And you cannot hide behind the president said or the presiding judge said. A judge who sits in a multiple bench is also responsible. And lastly, on that issue, you have done this as a matter of urgency. And by the way, we have said we have no problem with the decision you had to make it. You have done this as a matter of urgency.
By the way, just to correct you, my Lord, the Supreme Court cleared it completely.
Yes.
Said those returning officers were
that is fine.
Office, and that suit was null and void from the beginning.
That is fine.
Yes.
That is fine. But you know, justice is a process, and the person who brought the case is entitled.
Yes.
Is entitled to be given that opportunity.
Yes.
If it is, and though I don't think that the Court of Appeal dealt with it ex parte anyway. At least he had the chance to be heard. So you have determined this application. In fact, was there an appeal? And you see, you have filed. You have given orders which are basically final. Did you find out to say, okay, we have certified this matter as urgent? There is an appeal pending here. Why don't we fix it for hearing as soon as possible, because there is somebody who is concerned about this matter?
Thank you for that. But it is not judges who move the appeals. The parties themselves file the appeal. But I just want to refer you to the Supreme Court decision in that dispute, where that matter was actually completely dealt with, and they said there cannot even be an appeal. because the court that handled the matter had no jurisdiction. So no appeal rise. Yes.
Yes, no,
the matter was finally determined by the Supreme Court.
The point I'm making is that we have a disgruntled citizen who was treated badly by the court.
Please, can we read for him the Supreme Court decision?
No.
So that he can understand, no appeal lies. The Supreme Court finalized the matter.
This was process, and process is important.
Yes.
Yes. This is just about process. It's not about the decision.
Yes.
And that's the point I am trying to make. It's just
Yes.
the process. Because if, for example, and it is going to happen, it may happen, somebody is taken to court at 5 o'clock.
Yes.
What is the magistrate? What is the message we are telling the magistrate?
No, the circumstances are completely different. You cannot look at this case, which has had such a magnitude of a constitutional, causing a constitutional crisis to our whole country, to an accused person arriving to court.
Okay.
So we as judges, we look at circumstances the way they are, the way they are situational, the way they are brought.
Okay. Yeah, I will leave that issue there. Now, in the same case, you dealt with Anarita Kariminjeru.
The case of?
Yes, Anarita.
The case of?
Anarita Karimi, the famous case of Anarita. And you said that, look, this petition ought to have been dismissed and whatever, because it did not comply with the standards set in Anarita Kariminjeru. Nevertheless, we will continue to we'll go ahead to consider. Am I right? In a similar case, that is Trusted Society of Human Rights. You recall that case where the court robustly held that Anarita was good law. You recall that case? Held that Anarita was good law. That in fact the court should not depart from it. Yes. And in fact, in that case where the High Court judges said, look, as long as you are setting out something, we are entitled to consider it. But the Court of Appeal said, no, you are bound by it. Then in this particular one, you say, oh, by the way, your pleadings really are not up to that standard, but we will consider it. What is the state of Anarita Kariminjeru in terms of our jurisprudence?
In terms of predictability of the judgment and the law and the preparation of pleadings, especially when one is seeking an interpretation of the Constitution, claiming violations of their rights, Anarita Karimi is still good law, because you have to plead with particularity what were the violations, so that you inform the other party who has violated your rights. Usually it's the Attorney General on behalf of the government, and the court is also able to interrogate, these are the particular facts. So, you know, these cases differ according to the circumstances under which they are brought. So sometimes it's very difficult for a judge to give a broad view without the actual facts before the court.
And you know, this is why sometimes we have to be reflective. Because in the Trusted Society case, the court had dealt with a Chapter 6 issue, isn't it?
Yes.
And that is the High Court that said certain things, and the Court of Appeal reversed. And from the public point of view, the High Court had made a good decision, and because it led to the removal of somebody from a position. In this one, the public perceives that in fact CCK was doing the wrong thing, but the court excused non-compliance with Anarita to give a decision which was favorable to the state. So, is that something that the court should take into account in terms of how it deals with procedural issues, so that it gives everybody a fair chance, so that if you are saying Anarita is not good law, apply it across the board, irrespective of whether it is something that favors the state or somebody, or you just say it is bad law and let us all deal with it on the same plane?
Yes.
Yes.
Thank you. Actually, I'm trying to figure out the facts in the Trusted Society case. I'm not quite getting it, but as far as the CCK case is concerned, the point of departure was, first of all, there was no evidence that the DMS was a system that was capable of eavesdropping any communication. Number two, the process of consultation, public participation had not been completed. It was in the midst of it that Omtata went to court and nipped the whole process in the bud. So the process of public participation had not been completed, and therefore the problem that was there with the CCK of having to deal with the purveyor who had invaded the mobile telecommunication was still a problem there, recognized not only in Kenya, but regionally and internationally. And it's a problem that needed to be dealt with, but properly, with proper consultation to the public, proper agreement on how the system was going to work. So we did not say go install the system. We said go back, consult the public, finish the consultation, then agree with the public how to install it. But now if that judgment was to stay, the problem would have stayed in the market, affecting a cross-section.
So at the end of the day, we agree that an ARITA should be applied in the circumstances of each case.
Yes.
Thank you. Just two more questions, or probably one. In the case of, you remember the case of, this is a very straightforward question. In application of international law in Kenya, you are a trailblazer in that area. Article 2.5 and 2.6. I just want you to tell me, or to tell us, the application of international law vis-a-vis the hierarchy of laws under the Judicature Act. You know, the Judicature Act talks about the Constitution, statutes, those statutes that have been incorporated, common law, and Africa customary law. So you have a statute that has been incorporated, so it's legislation. In that hierarchy, where does the general principles of international law fall?
Thank you very much for that question. I believe the principles of international law will come after we have exhausted our constitution, which is very progressive, very encompassing. Sometimes it has even gone ahead of those international provisions. And it is very rare that we have exhausted the theories, the principles that are provided in this constitution. Then we go, of course, to the statutes. Then, of course, we go to the Judicature Act. And then we go to the international law.
Okay. Finally, I've looked at your CV. There used to be a firm called Shamala Koome. Did you have any relationship with that firm?
Yes, I used to work there.
You used to work there?
Yeah.
Why is it not disclosed in your CV?
That must have been an oversight because I worked there.
Yes, it is
and
not,
I did a lot of work for public while in that firm.
It is not in your CV.
Yeah, you know, my CV is very huge. I think if I were to write everything, then it will be a confusing
So are you
document.
saying those years were not pivotal in your...
They were years I count as practice, 15 years of practice.
So it is not there, and it's important to make a full disclosure.
Yeah.
Thank you.
Thank you. Thank you very much, Judge Majaja. Thank you, Honorable Judge Koome, for those answers. And now we want to request Commissioner Jero to please ask your questions. The microphone, please.
Okay. Okay, my lady, I want to go straight to your sample writings. Then after that, we'll discuss a bit about your CV. So generally, my questions will revolve around that I can understand your legal philosophy and generally what guides your decision-making process. Now, you know, there's this question of the case of Communications Authority of Kenya versus Okia Umtata. Now, and you correct me if I make a mistake. I noted that one of the reasons that informed you allowing the appeal revolved around the interpretation of the word access, which you found that the judge in the High Court gave a narrow interpretation of that word. And then there seemed also to have been the failure by the judge to balance the rights to the rights to privacy and as against prevention of abuse of the same right, and also the judge having gone ahead to stop a process of public participation, which eventually would have meant that this whole process, would have come to a standstill. I don't know that I'm right regarding those aspects.
You are right.
Yeah. So now, so my question then becomes that it seems to me that the issue of public interest that you are taking here into consideration. Now, then again, when I come to this decision of Teachers Service Commission, which to me seems to be groundbreaking, because the way we've always known about vicarious liability, there's that Salmon test that we all learned from the university, but the children who had been sexually abused by their teachers, TSC was found effectively to be liable because they seem to have, been unable to exercise their responsibility in a wider sense. Now, those two decisions, I would want to understand what is the critical, what is it that was driving you in arriving at those, at those positions. Generally, because there must be something at the back of your mind that was informing your judicial philosophy.
Yes, before the Constitution of Kenya 2010, we used to struggle with the theories that govern a judge's philosophy of judgments. But with the 2010 Constitution, it is replete with how we should interpret the Constitution. To breathe life to the Constitution, to give value to the value, to enhance the values that are given in the Constitution, to promote and protect the rule of law, to promote and protect the human rights of Kenyans. So the two decisions and public interest connotation, but differently. This is the Communications Authority that has the mandate of managing the communications for the whole country. It has been invaded by illegal mobile operators that have invaded the system. They are not paying the dues. They need to install an equipment, but there are many for everybody to understand this BMS is actually supposed to nip the illegal purveyors of mobile communications. And they do consultations, they go on and on, but in the middle of it, before they finalize, they are taken to court. Or communications authority is installing something that to eavesdrop on our communication. And therefore now that becomes a case. And then the judge decided, yes, it has breached the privacy rights, therefore it cannot go on. Now, what remains on the table is a problem that is unresolved. These illegal purveyors are ranging, they are running wild all over. They cannot, communications authority cannot carry out its mandate. So this was really a matter of public interest to define the mandate of a body, because then if the body that is given the mandate to deal with the communication is stopped from doing its work, that affects very many people. It affects also the economy of the country, because then East Africa, there were problems with Kenya and its communications. Internationally, because there is some place where they merge, were also uncomfortable about Kenya. So Kenya was about to be isolated internationally. On the TSC case, it's a matter of protecting our children. When you have taken your child to school, you will not stay to look after your child. So when TSC has employed the teachers, and the teachers are the very ones that violate the children, then we cannot leave TSC scot-free. TSC was saying, look, we didn't commit the violation, we punished the teacher. But he went on to examine what systems has TSC put in place to make sure that children are protected from teachers. Is there a standard operating procedure and in the court, I mean in the classroom, to say, you teacher, you cannot touch a child, and if you touch a child, you lose your job, you know, and also empowering the children that no teacher has any authority, I mean, to touch you or to do anything like this to you. So we saw TSC has some regulations, but they have not even cascaded them to the schools to protect our children. Our children are left to the mercy of the teachers, and we found TSC vicarious.
Okay, that's right. Now, then I've looked at this case of Ethics and Anti-Corruption Commission and Midland Finance and Securities Limited, where basically the respondent, again in the High Court, had sought to stop an audit that was being carried out by PwC. These are the Anglo-Leasing cases where the government thought that there was no value for money in excess of, I think, 4.9 million euros. That should be about 5.5 billion shillings or thereabouts. Now, but in your decision that you wrote, you are clear that that there was need to allow the process to continue of the audit, because in any event that was not going to determine, it was not, did not amount to determining the matter, and if the decision was to be allowed to stay as it was, in the High Court, it would essentially be prejudicial to, so to speak, public interest. Again, I'm not sure, again, if you could explain further what was the reasoning behind your decision, so that I can understand your judicial philosophy.
Yes, my judicial
Yeah, my lady, I think you are.
Thank you. My judicial philosophy in this was also informed by justice. As you mentioned, these were the agro-leasing contracts that were entered for an entity in the UK to come and provide security systems. There are many contracts like that. The contracts were running into billions of money. The contracts were signed, but when the NAC government, Kibaki government, came in the office, I think the Ministry of Finance questioned the validity of these contracts, wanted to evaluate them and see whether there is value for money, and contracted PwC, an audit firm, to audit these contracts. These bodies, Midrad Finance, which was supposed to finance the contract, came to court to say you cannot audit these contracts. And the judge of the High Court agreed that these contracts cannot be audited. So when the appeal came before us, we looked at it and said, under the rules, under the Constitution, accountability, value for money, what is wrong in evaluating a project? Even if I have signed a contract that I'm going to build a house here with the contractor, and then I decide, wait a minute, I relied on a QS, can I have another QS look at it? What is wrong with that? And that was the decision in that matter. We said PwC could look at the contract and give an opinion whether there was value for money.
And finally, when it comes to your sample ratings, I notice again this decision of Supernova Properties Limited, where the Mombasa court, actually, they had lost the title. Now, the party was claiming that it is their title, validly issued as far as you are concerned, but you looked at the matter differently and restored the Justice Tower to the public and the litigants generally, taking into account again the issue of the public interest. Now, how do you balance out the proprietary rights of an individual vis-a-vis those of the public when it comes to ownership to property?
Yes, thank you. That was a very difficult decision, and for the sake of the commissioners, this was a dispute of the land where the Mombasa Law Courts, the Justice Tower, is constructed. This land, I think, I don't know whether accidentally or was allocated, was grabbed. And the people who are allocated were claiming it, that it is our private property because we own it, we have the title, we are registered, and therefore we are to examine the proprietary rights like Commissioner Macharia is raising. First of all, before the rights of the judiciary were appropriated, judiciary was not consulted, and judiciary was in possession, rendering services to Kenyans. The arguments by these people who had been allocated the land were very strong. They are saying, look, we have the title. So the judgment is profound in the sense that it says, if a party is in occupation of a land, like judiciary was, and that land has to be appropriated by whoever, that body must be informed. And that body must give its consent. There was no consent by the judiciary. So whoever allocated the land, that was, I think, the registrar of lands or commissioner of lands, whoever it is, to these ROTs, it was wrongly allocated. If they suffered any damages as a result of that allocation, then I think their rights belong to civil matter. Is not, they had no right over that property.
Okay.
The Justice Tower is there. The Justice Tower is the temple of justice where Kenyans go to seek justice. And that's what we send in the judgment.
Okay, thank you. Now, let me come to your ears in, say, basically working both as an advocate and as a judge, because sometimes it's what you've done that will speak mainly about who you are. Because in an interview, anybody can say anything, but we are more informed by somebody's past. And now, I remember you actually when I started practicing, and the Mother Koome I knew is the one who was, always out there with the Law Society, fighting, these issues. So the second liberation, the issue of political rights and detainees and all that. Even demonstrations. In fact, that's the Mother Koome I remember.
Yes.
Before she became a judge. Now, I would want to understand what was motivating you into all this? Because there are many of us who are in private practice who prefer that this is somebody else's problem. I would want to understand for you what exactly is it that was driving you into all this?
Thank you, Commissioner Macharia. I think what was driving me was I was seeking justice. I was representing the public. Those were public interest matters. You remember during the one-party rule, the Kano government was closing in to take over all the independent institutions. The judiciary was part of the executive. Maendeleo ya Wanawake, the major women's organization, had been appropriated. It was Kano Maendeleo ya Wanawake. The KOTU, the workers' movement, the Kano government was trying to take the church, the NCCK, and the Catholic Church, but they were resisting vehemently. The Moi government was also trying to take the Law Society. In fact, at the point at which I became an activist and a campaigner for the constitutional review, independence of the judiciary, is when there was an attempt to influence who becomes the chair of LSK. So I was driven by public interest, the search for an independent judiciary, because I was a young lawyer and I could see unless we have an independent judiciary, then I have no future as a lawyer, even if I have my own practice. So that's why I joined with other lawyers and we started the campaign of review the Constitution, review the laws, repeal Section 2A. Section 2A was repealed, but the institutions of one party still remained. We campaigned, we had the 1997 IPPG, partial reforms that even introduced, some little affirmative action in nominated seats, so that nominated seats and to take into account gender parity. It never happened. I remember myself on behalf of FINDA with Jean Kamau suing Moi, the president then, for not complying with constitutional amendment that required gender parity. But of course the case was struck out because it was saying we could not sue the president who was in office. He was immune from civil and criminal liability. So this is work we did at the Law Society. FIDA also realizing my clients whom I was representing, because the firm where I worked when I was first admitted as an advocate, I was a junior associate, so the partners would not take cases for women. They were time consuming. The women had no money to pay, and they said these women they require a lot of emotional support. They cannot render them a shoulder to lean on. So those cases were thrown to me. And as I came to court, I saw how difficult it was to convince judges using 1882 Married Women's Property Act to say this woman who has been married for 20 years or or more, or even 10, has been thrown out of our matrimonial home, she needs a share of the matrimonial home, she needs maintenance, children, all that. I saw how difficult it was. So that's why I joined FINDA, so that we could solidify our voices and seek law reform that took care of families. Because families are important. Families are the foundation of the society. So I've always been driven by the quest for justice. And whatever work I do is defined by the situation in which I am in. Whatever God puts in my hand, I try to do better. I try to be innovative. I try to achieve the very best from the circumstances. So when I was at FINDA, I was a firebrand because the work required me to be a firebrand.
Yeah, which is where I'm coming to actually, FINDA, because that's the other mother Koome that I knew of before the judge. Why gender equality and children? Because again, the mother Koome I knew in private practice was so firebrand, apart from, of course, the political issues on women rights and the children. I would want to understand what exactly, because this seems to have been your life, even up to date, you know. I'm not faulting, I'm actually
Yes, yes.
It's something I like.
Yes.
You know, there's nothing negative about it, and it's something I'm also passionate about. That's why, but I need to understand why.
Yes, I think I'm an all-round lawyer. Even when I was practicing, I was a conveyancer to boot. By the way, I was representing some corporate clients who were actually able to pay my bills. I practiced in the Mirimani commercial courts. I practiced land law. I was an all-rounder. But what pricked my conscience was the violation of women's rights and children's rights. And this was a threat to the family. And this was a threat to the country. You cannot have a country where families are acting. Because if you're okay at home, everything is working at home, even when you go to school, you will excel. Even when you go to do business, you will excel. But if there is skirmishes at home, there's no peace at home, there's no harmony at home, then you cannot thrive anywhere. I perceived women's rights and children's rights to be central to the family because they anchor the family. And I realized there is a big gap. For women, there were no laws completely. You know the raft of laws that have been enacted from the matrimonial properties, protection against domestic violence, matrimonial acts, all those acts that have come were not there. We were relying on those English-owned registrations, and we used them, argued cases all the way to the Court of Appeal, and they became precedents to inform the future review of the laws. And children as well. Children's laws were scattered in 17 statutes before we came up with the Children Act. And children are vulnerable because they are young. They don't speak for themselves. Somebody needs to speak for themselves, to speak for them. Today, we have this Constitution 2010, which is very progressive. But the Children Act has not even been reviewed and realigned with the Constitution 2010. But I'm proud to say the committee that was put together by the NCAJ, which is a body of this JSC, has worked on a draft children's bill, which is currently at the floor of Parliament for consideration.
Okay. Yes. You were involved in Echaria versus Echaria?
Yes, I was. Echaria was, Priscilla Echaria was my client.
Yes.
Yes.
Now,
and it went all the way to the Court of Appeal.
Yes, I recall. And that's why I'm saying I remember that again when in a private practice.
Yes.
Now, what is your take home in that matter? Because, of course, it's one of the major cases that have been used again and again when it comes to issue of a matrimonial property.
Yes, I think the Constitution and the Matrimonial Properties Act now have settled the issue completely. So we do not have to navigate the 1882 Married Women's Property Act, English registration, and precedents from outside the country. We are good with the law as it is.
Yeah.
It defines what is matrimonial property, what is direct and indirect contribution, because the ratio decidenda in Sharia case was a contribution, especially indirect contribution.
Yeah.
When a woman is married, say she is a housewife, but she is looking after children, she is doing household work at home, looking after the husband, supporting the husband and the children. When it comes to the division of the matrimonial property, what value can you give to those indirect contributions? So I think the law now is clear. So we won't go into the merits because those are ripe disputes. Yes.
Which brings me now to the question. Of course, if you become our Chief Justice, you are Chief Justice of all. But this issue of gender equality and children's rights, we seem to keep throwing it to the back burner. High-sounding statements, political statements and all that, but we don't seem to get it right. Now I'm wondering, as the leader of, the one to guide the jurisprudence development at the Supreme Court, the apex court, and generally also cascading it, within the entire judiciary, what steps would you take as our Chief Justice to ensure that, we're able to also use the law to resolve this issue? And I say this because we must accept that countries that have done very well when it comes to gender equality, they are doing very well, but we seem here to keep, struggling and fighting over it as if it's a bad thing. It's like we have to fight over it. And when I say gender equality, both ways, because again, we also don't want it to now move against men. But what would you do, finally, if you're given that opportunity to make sure that you're able to run with this agenda and we sort it out?
Thank you. I think the law is established, and that's the first step. But as we know, laws are always not the panacea of all the problems that we have. We have a big problem in this country of creating awareness, informing people that this is the law. For instance, I wouldn't understand why somebody in 2021 would tell a daughter of a deceased person that she is not entitled to inherit the estate of the father. It is there in the Constitution, it's there in the law of succession. So we have our own cultural beliefs, cultural practices about what we perceive a woman to be, but this is all a matter of education. We will get there. The cream will come on top. Because we will get there. It's a matter of campaigns, and I see we have a good entry point to do that through the Court Users Committee, which is a multi-institutional stakeholder body, involves everybody. For instance, when I was in Kitale, we had so many problems of child abuse. And the court users decided we cannot stay downstream waiting for children to be defiled and cases to come to court for the court to sentence these people to 20 years. Because when you go to jail, you find the majority of the convicts are sexual offenses. So that court user committee of Kitale Law Courts decided we are going to do a public education campaign. I was the chair of that court user committee, but I never went to any of those barasas. But they went to the chief's barasas, they went to the local radio to explain to people, here is the Sexual Offences Act. This is what it provides. It's a very serious act. If you listen to those radios, they were using very good examples. They were saying, if you go and violate somebody's daughter, you will suffer the consequences of the man who went to milk an elephant. So when you use those terminologies, you now reach out to the people for them to understand what it is, what does it mean to milk an elephant. You will actually die, you won't leave the place. So that is what it means to violate a girl, to violate a child.
But my lady, my only concern is that being a patriarchal society, which you also mentioned, you find that it's your judges who, when they're interpreting the law, will also be informed by the same prejudices in interpreting the law, they come up with the same prejudices that, you know, they are customary and, you know, their background, their history. So which is why I'm trying to understand what would you now be able to do, even so that even when the interpretation of the law is being done, is done in a way that is also able to promote the same principles of gender equality and
Yes.
protection of the vulnerable, particularly the children.
Yes, I think when I'm CJ, the colloquiums, we will spend some time to get judicial officers understand what is required of us by the Constitution when you are making a decision. Your personal beliefs, your cultural beliefs, your religious beliefs, your own attitudes, you have to put them completely in the back burner. You just have to embrace the Constitution. Give interpretation of the values that are provided for in the Constitution. Give the meaning of the law as it is. It doesn't matter who you are. And then the rest, those who have received that judgment will grapple with it to see how to implement it.
Okay.
Then that becomes another stage
Yeah.
where we still go back to the court user committee to explain to people, you know, that if it's a judgment of the court, you have to appeal if you're not happy with it. If you appeal, you lose, then you have to live with it.
Yeah. Now, I want to spend my last few minutes on matters now that relate directly to administration issues, administration of justice within the courts, because it affects lawyers and, of course, by extension, the people that they represent. Because lawyers generally don't represent themselves, they are representing members of the public. Now, you mentioned about Kitale, where you went and the court was not functioning for about a year. And then you went there and, of course, you know, you resolved the issue, which is a good thing. And this has not been uncommon. I remember there was a time when the same problem was there in Eldoret. Lawyers were not being heard, they were complaining, and the courts were not functioning. There's a time it was happening also in Kakamega. So different parts. Now, how does a Chief Justice responsible for managing the institution allow a problem to simmer for a year, which is not just affecting the lawyers, but also affecting members of the public who need to access justice? How does that happen? What exactly is the reason that it's allowed to escalate to that level where, you know, the system of justice has come to a standstill for a year? And for you, what is it that you do to ensure that you don't have those kind of situations?
Yes, that is a very far-reaching question on the administration of justice and the relationship between the stakeholders, the bar, and the bench. I think modern management of the courts that are now well run by the principal judge for the High Court and for the courts of equal status, the end of the station. You know, I see now a better structure than prior to, you know, the reforms in the judiciary that would respond, I think, faster when there is a stalemate like it was in Kitale. Knowing how proactive even our acting Chief Justice has been, a problem like this will not even last a week before she has addressed it. My lady has been quite at hand to deal with it. This is a problem that should not be around to pester. Immediately it is brought to my attention. If I am Chief Justice, I would address it and find a lasting solution to it. The lawyers there were unhappy with the judge who was there. So that is a matter really to sort out quickly. It didn't have to wait for me to be sent there a year down the line. I could have been sent earlier. So that's another, you know, a style of management. When you have a complaints office, you don't expand the complaints office. You deal with the complaints as they come, you know. Then you don't have to be overwhelmed and you don't have to clog the system with the complaints. Deal with them as they come.
Yeah, I agree. At least currently things are working better.
Yeah.
Now, there was an issue that was raised by Commissioner Warsame, where during your time as judges you are few and you'd be able, the output was much bigger, which is true, because even I have now practiced for that years, and when I compare when the judges were fewer, things seem to be moving than now that we have many judges. Now, and he addressed the issue of, say, for instance, of the commercial division. And I'm just using